Hi, everyone. Welcome in, and thank you for joining today's Collab hosted by Visas.AI. I am joined by wonderful attorneys. I'm going to pass over the mic to John. John, how's your week been and what you've been working on?
It's been exciting. Plethora of different exciting things. Just got off of out of a really interesting meeting with a woman that some facts that aren't all that common, and so she came to the United States on a B1 B2 visa as a visitor. Um, Fell in love, got married to an American citizen, filed a marriage green card, all within the 6 months. So this is almost like a law school fact pattern. What's the problem here? Well, some of the problems could be: is it a real marriage if you get married, meet somebody and get married within 6 months? But that wasn't an issue. What was an issue in this case, and she's been denied 3 times on her marriage-based green card, had nothing to do with her. It had to do with her husband had been convicted of a very serious crime. In fact, her husband is in jail for committing that crime a second time. And they denied her green card, even though she was legitimately married. That wasn't an every issue whatsoever. And I had not seen that before, right? Now, we do mostly business immigration law. We've done plenty of marriages over 30 years, but I've never had one denied because of the American citizen. Matter of fact, I didn't even know that was a thing. So learned that they had that denial. It was a pretty egregious crime. It was a sexual assault with a minor, like as bad as it gets. And I can totally understand um, it at one point, but the American citizen isn't the one being denied entry into the United States. The the committer of that crime is still an American, and is dealing with their punishment, right, by being incarcerated from it. But the foreign national was not has not committed any wrongs. Yes, there she is. So she told me a little bit about her situation. So to go on with the law school fact pattern is that she said, I've been a target of cartels. She's Mexican in Mexico, and I think I might be eligible for a an asylum case. I'm like, okay, well, do you know that asylum cases need to be filed within a year? When did you come? She said, well, 2013. I said, well, obviously that's 10 years. But there are exceptions to that year, right? And so I looked up the exceptions, and there are broad ones like changes of circumstance. There's actually even an exception that if you're married to someone who filed an asylum case and you're no longer married to them, that's a change of circumstances. So the question is whether or not somebody that filed immigration pathway 1 within that year could now, after that was denied over a 10-year period of time, could go to immigration pathway 2. And I feel pretty good that she could, right? I think that she could have filed asylum. She chose to file marriage to a U.S. citizen. And when that didn't happen, at no fault of her own, so she didn't commit any fraud, she didn't lie, no one felt that she didn't do it. It was just that her husband's facts made her ineligible for the green card, right? So I think we could get past that. But now start looking at what was the political group she was under? How could she get asylum under this? Well, she is from a family that owns a really nice restaurant in Mexico. I won't go into the details of where it is or anything like that. But what these cartels do is they target family members of wealthy people. They don't just kidnap the guy that owns the restaurant. So her cousin was kidnapped. Not sure if the cousin was killed, but definitely held hostage. She has become very um, become a complainer, I guess, has become active in speaking out verbally against what the cartels are doing and how and then she's helping victims and stuff like that. So she's using social media as her, platform to do this. So I was looking at it, and it was really interesting. I was just reading an article to kind of get up to speed on it, and there were a massive number of Mexican asylum cases filed in one of the years recently, and only 2% of them approved, right? Really, really low. And part of that is like we're doing these Afghan asylum cases. Those really fit the criteria. You've got you've got political beliefs of those who believe in democracy, right, that are fighting alongside Americans, and they are being targeted specifically by the Taliban because of their different beliefs, political beliefs, right? And those cases are all getting approved. All of ours are, by the way, special asylum type of deal. But our clients, have been shot at. Our clients have had notes put on their doors, and our clients' family members have been kidnapped. All sorts of horrible, horrible things that happen in their life make an easier case for an attorney to win, right? So in this case, it's a little bit different. There's been some time since her family was kidnapped, but can you imagine what it's like to have a family member kidnapped because of this? So it'll be interesting. So we did find that there was a case that was successful in the Mexican asylum cases on behalf of a reporter, right? So this reporter was talking about the problems of the cartels and what they're doing and how the police are, effectively in bed with them, and they're not helping anybody out. And that in this guy's case, another reporter was killed, right, for having done something similarly. So, he so here's a lawyer's opportunity. Do you make the argument that her use of social media to complain against the cartels is a similar or analogous to the reporter who's complaining about them in another media? And maybe back in the day that wouldn't have been such a good analogy, right? But now social media is every bit as effective as actual media, right? We see actual media on social media, right? So it's really interesting case. I don't know if we'll take it. I just went through it today, but it was just fascinating, and I thought of Collab as an opportunity to talk about these interesting things and where we go with it. So anybody else want to talk about asylum or why that's interesting? Yes. Do you have any thoughts on this case?
I haven't had too much of asylum experience recently, but I I've had one where we screened somebody, and we got her through the credible fear interview. She was an individual from Mexico. She was part of a group, or was part of a small group where they would help underprivileged women get the resources they need, and all of that. But she spoke out against her supervisor for mishandling these funds.
Mm,
And I guess the supervisor just had the local cartel stick they just stuck him. And so she was actually physically abused. And what's weird is when she went from her city, the city that she was living in, to her hometown, they followed her. The threats followed her. And they
mm,
said, our we were given orders to deliver you back in a coffin and stuff like that. It was very explicit. Yeah, it was very difficult. And then so we had to kind of walk her through what the credible fear interview is, because when people when people come across
Yes,
the border and
sorry,
they
sorry to
attend
cut
these.
you off.
Oh, sorry,
Can
go
I
ahead.
can I ask you for the credible fear? Can you elaborate on that for those of us that are non-attorneys?
Right. So when you come in seeking asylum, you essentially have to go through a preliminary interview. It's not with the judge, it's with an officer at the border usually, or at one of the facilities. And they want to see why you're asking for asylum. They want to see, do you actually really have a case, or is this something? It's like the smell test, I guess, if you want to say. Um, and the difficult part of a credible fear interview is, if you whatever you put in there, or whatever issues you raise, those are the ones that go in front of the judge, or those are the only ones that you can talk about. If it goes in front of the judge and you say, "Oh, I forgot to mention these facts," the judge won't allow it. And so that's like the preliminary test that you have to pass. And then they'll let you into the country, and they'll give you a date, or they'll say, come back and report to ICE on so and so date, so that they can keep tabs on you until your court date is available. So to get her across that, it takes takes a couple hours just to get to the nitty-gritty details because you have to really give all of the details that you can to put your case in best light. Because if people go in there and they're like, oh, well, I was, the cartel threatened me, and that's all they say, that's not enough usually for the officer to kind of say, okay, well, you might have a possible asylum case, we'll let you through, and then then you can, go into the country, enter into the country, and then, go for um, a court case, like in front of the judge. Um, that's the most recent asylum case that I actually experienced in this year. Most of what I work is business immigration. So not a lot of asylum cases. We do have a lot of family-based, we work on a lot of family-based cases. But coming back to that first point, I've never had a case that was denied because the citizen
Right. Isn't
was
that
the
interesting?
issue.
Yeah, I didn't even know. Never faced it before. It's really interesting deal. And I don't know the answer. And if we do engage this client, maybe there's a process for waiver
Mhm.
of that. But what makes that interesting that I think that, and again, I don't know this, right? I'm going to say that right now. Don't rely on my legal knowledge here because I'm asking the question. But is if you commit a crime as the foreign national, there are processes where you can have a waiver of that crime, right? And so a lot of those things, it's discretionary, go into how long has it been? Are you remorseful for it? Those are the types of factors that go into that. So I don't know if an American citizen can do it. I would assume they could, but I don't know that. But it'd be interesting to see if that's it. Now, this person is incarcerated for it. So I don't think that somebody that's currently incarcerated for a crime can be remorseful for it, but I don't know. So be interesting along that.
Is
I don't
it?
think she's looking
Oh,
at it for that. What's really interesting for her, though, is that she's also been a victim of a crime and she has filed a U visa, right? So here's an interesting thing that attorneys come across. The U visa takes a long time. And one of the things I don't know about is how long it takes to get an EAD card if you file a U visa. Yes, do you have any knowledge on that?
I haven't. I know the U visa to get a green card right now. Practice wise, it's taking around 15 to 20 years, is what
Right.
we recently
Yeah, we
heard.
talked about that on this show.
Yeah. Um, the EAD card, I'm actually not sure. Believe there's one that I guess it's taking 2 years, if I'm not mistaken, but please don't hold my feet to the
And I
fire
think
about
that's
that.
why she came in the office, right? I think that she has a U case. I think she thinks she has a good U case. She's filed the U case, and I think her EAD is taking too long, so she can't work, right?
Oh, the U case. The U case is what we spoke about.
Yeah, the
It's
U case is if you're a victim of a crime,
yes.
right? And the tough part of a U case, and again, thanks for bringing that up here because we can jump in the weeds real quick, can't we? So in a U case, if you're the victim of a crime and you can get a really a police officer to sign off on the form, then you can file the U. And as we talked before, and yes, just reminded us, it can take 20 years to get a U done. Now that's not always a big deal because you're here, you're living life, and things can change where other visa applications might come in play. But the EAD card is what gives people the ability to work. And if it's taken 2 years, that's probably why this person came in to see, is there something else I can do? And wanted to know about asylum. So, from a legal perspective, you could have an asylum case and a UV case going, right? Matter of fact, if she was to divorce her husband who's incarcerated and legitimately got married to another American citizen, she could also do that. As a lawyer, we have to be very careful about those things, right? We can tell them what the law is, but we should never suggest, well, you should divorce your husband and marry somebody else for immigration purposes, right? Now you
Okay.
are committing fraud if you do those things. We should never, ever do that. And we have to be very careful when we're asked those questions, right? It's an easy thing to say is just say I'm not interested, but not so simple sometimes. If someone says, "Hey, I'm gonna marry somebody, will you do my case?" If they tell you that it's not a legitimate marriage, I wouldn't touch it with a 10-foot pole. I'd say no thanks, find somebody else. It's not worth my license. That's different, right? Criminal defense attorneys defend murderers, right? But they didn't help them murder anybody. So the difference is this is prior to the crime instead of after the fact, right? So I want to take this back to business immigration, right, for a second, right? So on H-1Bs, where we're seeing a little bit of prosecution is in the double registrations, right? And so the double registrations, to give some background on that, is if a company registers for the beneficiary, the employee, twice on an H-1B, then both of those cases will be denied, right? That's what the regulation says. What's happened is because so many people registered for the H-1B, that a year after the final rule that talked about double registration came out, USCIS said there's a penalty of perjury, and they are extending that to companies that have commonalities that file for the same beneficiary, meaning it's not the same company. It's not even a related company. It's just these commonalities. We're seeing examples of they share the same accountant, they're in the same building, they had an employee that used to work for one company, now works for the other. All sorts of different things are being commonalities. Now we've seen a lot of that from a year ago. I haven't seen much of it this year, but in that because they really scared people away on it so much. But in that instance, there's two things. One is a client coming to you and saying, should I file this H-1B? That's tricky for us, right? Because if you tell them to file it and they get this RFE or they're found of fraud, then they're going to say, well, you told me to do it, right? So you want to be very careful if somebody asks you that question. What you can do is lay out, here's what the law is, and let them make their own decision. Show them what I've done is show them, here's what the final rule says. Here's the comment and answers of the final rule that said that related companies can actually file registrations for the same beneficiary if there is a reasonable purpose for doing that. I think that allows you to do it, unless you literally try to collude to commit fraud. That's what they're talking about, that you really have gone into fraud. I think it'd be very hard for USCIS to prove that. But there's the other thing, and that's when clients come to us that have already done something, right? This is the equivalent of the criminal defense attorney that somebody murdered somebody and they're going to try to defend them, right? So when somebody has double filed, I relish those opportunities because I think USCIS is overstepping. I think that they are too restrictive in their reading of their own regulation. I think they've added the punishment after the notice and comment period was over, and I really find it hard to think that what's happening is actually fraud, right? And that's a big nasty word that can ruin people's lives and get their companies shut down, right? If you commit fraud, there's civil fraud and there's criminal fraud, but any findings of fraud are really devastating. For example, if a beneficiary has been registered by two companies and may or may not know it or understand the significance of it, it's not a big deal. But then one of those companies has had a finding of fraud against them. It's also a finding of fraud against the beneficiary, and that carries with the beneficiary forever, right? So John Wasden's suing USCIS on those findings of fraud for the beneficiary, which I think is the lowest hanging fruit. What I don't think is happening yet that I know of is attacking USCIS for findings of fraud against the companies not being fraud and not following their own laws and looking at those things like, is it in violation of the APA to have this prosecution after the fact? So really fascinating time. And so there's taking my analogy of asylum into business.
That's excellent, John. Thank you so much for that. I do want to ask you a quick follow-up question, and then we can move to the next segment and hear a
Sure.
little bit from Yesh. I know she's been working on lots of H-1Bs this week, but when it comes to the conversation that we were speaking about, asylum cases are really sophisticated because, we speak a lot on extraordinary ability and its evidence and how to prove it. Asylum, on the other hand, seems to be something that you can't necessarily work on. You can't go back and work on making your case more traumatic, right? It's either traumatic and bad or not. But I'm really curious to ask the question, the spectrum of a case qualifying and not being good enough to qualify is huge. It's big. What about TPS? What does TPS really represent for people from, let's say, South American countries that are going on TPS but still have an active asylum case pending?
Well, TPS is stands for temporary protected status, right? So that gives you a status in the United States, but it doesn't always last forever, right? They uh, they pull them, right? So if a country is no longer as TPS, what are you going to do? So TPS means you must be a national of a designated country for TPS, or a person without nationality who last lived in one of those countries. So you got to file for the status during a specific registration period. You have to have been continuously present in the United States since the most recent designation from your country. You have to continually reside in the United States since the date of that specific thing. So that's when people do it. And but they often file asylum cases too, because asylum will provide a permanent solution, where TPS, even by its name, is temporary.
And does your firm deliver that service of TPS, or is that a self-petitioning sort of process? Or
We
can
don't do a
can
lot of TPS. We don't do a lot of it. We're mostly business immigration. We run into people with it more often than not. College students who are on TPS that go to college and then come out of it. So recently we had a Somalian that was in that scenario.
Mm. Well, that's a great transition business, corporate visas. Yash, welcome and thank you for being with us. H-1Bs are a huge conversation, and I think H-1Bs are what everyone is here for. They really want answers. They really want to know what you've been working on. I think the majority of our audiences come with questions about H-1B. So instead of asking questions, I just would love to ask you what you've been working on, what you've been seeing, and anything you can share with us on the cases you've been working on without sharing any confidential information, of course.
Oh, thank you. So yeah, it's not a secret that my focus right now is on H-1Bs. We do have the last day to file for USCIS to receive any cases from the second lottery is October 31st. Um, and right now, since it is October 20th, if you have not had an LCA filed, it's up in the air right now. If you file an LCA, you may or may not get it in time, because even I guess the last day to mail out anything to USCIS would be Monday, and you have to overnight it for them
Yeah.
to reach by the Tuesday deadline. And LCAs usually take 7 to 10 business days. You may get lucky. If you file it today, you may be able to get something by Friday of next week or Monday. But that's where we're at. My main focus is I've got all of my LTAs out. My main focus right now is to actually work these cases to completion and get them out by Friday. So that gives us enough time to, review them adequately, so that there's no mistakes. They're make sure that they're going to the right servicing centers that the registration's at. And so that's kind of where I'm focusing on. There's a couple of RFEs that came in, and a lot of it, what I'm seeing is just adjudicators just issuing out ridiculous RFEs, and they're not looking at the proof that we submit. I guess they're again probably overworked, and they just are buying time because some of these RFEs we see, they're just we provide them the proof and they're not even reading it, and they're saying, oh yeah, you didn't provide this or you don't meet this qualification, when you look at the packet and the brief that we submit, we explain, we laid out clearly, hey, this person meets specialty occupation because of A, B, and C. And they're just, that's kind of where the situation we're at. I think it's a lot of, they have more cases coming in, they just don't have time to adjudicate on these cases, especially if you're not premium processing them. And so
So
that's my biggest issue right now, is dealing
what
with
are the
these.
actual issues you're seeing? What are Give some examples of the issue, what they find insufficient with it, and how you respond to it.
Some of the cases that we're seeing right now, or the RFEs that we're seeing is, they're asking about employer information. Um, They're asking to see, hey, do you file your taxes? Does your company file your tax? Does the company file their taxes? Do they do their 940s, 941s? Do they even have space? Where are these people working out of? You're petitioning for, let's say, five employees. They want to know where these employees working out of. Is there a workstation? Do you have an office, or is it like a virtual office where you just get your mail and you have somebody that forwards the mail to you? We're seeing RFEs about beneficiary qualifications. A lot of these are from companies that are doing these equivalency certificate or equivalency letters, but they're not I guess the evaluator's not qualified enough, or USCIS doesn't consider them to be qualified to give out these equivalency evaluations. And so we see a lot of pushback from USCIS about this right now. And so I guess the way to mitigate that would be just to make sure that you go through an evaluator that is qualified, that is allowed to give these evaluations on behalf of a university, just to say, well, you have a bachelor's, let's say from France, for 4 years bachelor's degree is equivalent to a 4 years US bachelor's degree. Um, and so that's more of like the typical ones that we're seeing right now.
So
Majority of them actually.
let's dive into both of those so we can give some nuggets maybe that some of the attorneys can take away on that. So the first thing you're talking
Yes,
about
please.
is pretty interesting because it's an attack on the company, right? And
Yep.
so if you look at the history of immigration, most of the attacks have been on the beneficiary, right? Very seldomly has immigration really attacked the company. And we've seen it in the business model of staffing companies that has really started around 2010 and has been taken a number of different forms at primarily companies owned by people of Indian descent. And part of that, I think, is immigration hates numbers. So 70% of H-1Bs are filed for the tech sector, and 70% of the tech sector are filed by Indian, related companies. Now, these are American companies, by the way, that I'm talking about. These companies are incorporated in the United States. They're American companies. They pay taxes in America, and they hire they hire Americans and they hire foreign nationals on visas who spend their money in America. And it's really interesting, this attack on them. And we've seen this attack come in a lot of different ugly ways. One is that H-1Bs are stealing our jobs. Now, there are anecdotal evidence that some people may have trained somebody that they work to replace them. That was one they threw out there. But statistically, it's ridiculous. Number one, the H-1B is less than 1% of the entire economy. Number two, H-1Bs create jobs for others, right? I've seen statistics that in big companies, they create almost 2 jobs for every H-1B. And in small companies, it's between 6 and 7, right? For every H-1B. And think about it, right? So you bring techs over. Now you have to have management, the higher paying jobs of people overseeing it, and all these other things. And when you move those jobs out of America, guess what jobs gets taken away? The middle management American ones, the guys that are and women that are making 6 figures, jobs disappeared because they couldn't get their techies into America and had to outsource them to India. And they're not going to pay this guy to be oversee it in India. They're going to pay somebody in India to do it, right? So it's been ridiculous. So what we've seen now recently is this attack on H-1B companies around fraud, right? That they're double registering for an H-1B applicant. Let's talk about what that thing that they're putting all these resources to. This is where a company tries to hire somebody and is registering for a lottery, right? Wherein the beneficiary can have as many companies as they want register for them, right? As many. They can have 100 people do it. There is nothing. And that's what it should be, right? That means you can apply for your job with as many companies that could possibly give it to you. Now let's talk about this. It's a lottery in March, right? Or a registration in March for a lottery that starts in April for a job that didn't even start till October. So how hard it is to hire somebody that's 6 or 7 months out from when you're going to hire them, and that you got to pay all these legal fees for it, and you don't even know if you're going to do it. And only 14% of the people that applied for H-1Bs got picked up in the lottery. 14%, right? And then they went and scared all these American companies to not file the H-1Bs because of double registration, which is legal for the individual, but not legal for them, and not just in the way they described it. You can't do the same person twice, but if you have any commonalities with other companies that did it, you shouldn't do it either, right? That is what has been persuaded to this. Now they're attacking companies in a different way, right? They're attacking companies if they're too small, right? Well, that's what the things that you talked about. They're asking the questions. They're like, how many employees do you have? Show us your payroll records. Show us your space, right? They're taking issues with a virtual office, right, or a shared office like a Regis or something like that, not being sufficient. Well, no Americans held to that standard. I would say there's more than 1 million plus companies in the United States that people are running out of their houses, out of their, look, it was COVID. Lots of companies are now in houses. Lots of employees are in houses. But USCIS has continued on creating a more restrictive and harder analysis on how these companies, right, can hire foreign nationals and stuff like that. We have to train them that way. We're like, look, we know it's legal for you to have a shared office, but immigration may not approve your visa. So we suggest that you pay more in rent to do that. Well, I don't need all that rent. Well, do you want your visas approved or not? Right. I mean, that's the kind of conversations we're having with our client. There's also how many employees do you have, right? So we always tell people don't ever apply for your first employee to be on an H-1B, right? Don't be at 0. But really, we're giving them the advice, don't do less than 5. That's not a law, but that's just what we're saying is a best practice because we're seeing companies get attacked. Like, yes, you're seeing in that. Newest use is a thing called VIBE, right? VIBE is an acronym that USCIS use, and it's powered by Dun and Bradstreet, which is a company that provides essentially credit scores for corporations. And if they don't see you on Vibe, then they're kicking RFEs out and saying, well, we don't know if you're a real company or not, right? So they're using all sorts of tactics to knock down these cases for really kind of ridiculous ideas, really, if you think about it, right? I mean, at the end of the day, the judicial system has come down on immigration for just why are you asking all these questions? Why is this relevant? If a company wants to hire an American, they have the requisite degree, and it's really specific degree you have to have, and they're going to pay them the prevailing wage. You shouldn't even be asking them where they're going and who their clients are and stuff like that. It's beyond the scope, right? But now they're doing it in another shape. They're just picking on these companies. And here's the irony, right? Our big companies in America have laid off lots of people. You know who's picking them up and keeping them in America? These smaller staffing companies, right? They've done it in 2010. They did it and they're doing it again now. They're keeping jobs in America, which are keeping American jobs in America. But for whatever reason, this overworked agency that can't turn around an EAD card in less than a year is putting its resources to trying to shut down and harass companies that are just trying to hire people. And it's quite silly. So that's that first part. The second part you're talking about is the sorry, you were talking about remind me what
Evaluators. They're
evaluator.
being, yeah.
This is also an interesting thing that it's attacking. So there are evaluation companies that were around before I started practicing law 30 years ago that are being attacked because of their business model. And so with their business, let's talk about what an evaluation is. All right. So to get an H-1B visa, you have to have a degree, a 4-year bachelor's degree. Now, some degrees around the country or around the world are not 4 years. England has some 3-year degrees. Australia has 3-year degrees, and those aren't sufficient, right? But the 4-year degrees also have to be equivalent to a United States 4-year degree in that course of study. So sometimes a foreign degree might call it electrical engineering or electronics engineering, but that might be equivalent to a computer science degree in the United States. And so evaluators will do that. Now, the evaluator must be authorized by a university to make those evaluations, right? So they have to be university professors, and the university has to give them this authority. So that's a pretty high standard, right? It's not just anybody. It's not somebody in the tech field, right, that actually knows this stuff. It's a university degree evaluating official. Now, these companies are using these folks, but because the company are hiring them and they're not being hired directly by the company, they're devaluing them and saying they're not good enough, which pretty ridiculous. So again, we just kind of bounce to what they're doing, and we'll say, oh, well, we know some guys that you can hire directly. Got some really great ones that you can do. You don't have to go through these other companies. Probably charge you a little bit less since you're not paying an overhead from it. But I still think it's not fair to those other companies that at the end of the day, the person that's doing the evaluation meets that standard. What does it matter that you pay another company to go find them and vet them? Right? That's their business model. It should be fine. But yeah, those are two interesting ones. Yeah. So thanks for bringing those up, and thanks for giving me an opportunity to sort of give it some
I love
analysis that
it.
might help how to do it.
Excellent. John, I'm going to bring it back to you again. So,
Okay.
on the DOL.gov website, the US Department of Labor, there's a dedicated page called the H-1B Debarred Disqualified List of Employers. What does that
Okay.
mean? Does that mean,
So
do you,
debarred is an interesting word that means that if immigration finds that you're a violator of either a significant enough violation or maybe repeated violations, then you would be debarred, right? So these companies right here are have been determined by the Department of Labor. So there's two agencies involved with the process of an H-1B. Yes, talked about the LCA. LCA stands for a labor condition application, and it is a process that takes about 7 to 10 days. And you cannot file an H-1B with USCIS unless you've obtained that DOL. And why Yesh is saying we need the LCAs now to get them in on time is that you can't file it if you don't have them. And the DOL doesn't always issue them. They have glitches sometimes, their system goes down sometimes, and it's a big headache. So DOL can debar or USCIS can debar a company for violating immigration law. And it's usually like other crimes. The first time they probably wouldn't, but if they see a pattern of it, and it may be the first time you're in trouble, but if they see you've done something that they find is in violation of a regulation, 20 times the first time you did it, they may debar you, but it doesn't happen a lot, but it can, and that's and that's what you just showed us.
very good. Okay, excellent. Last question that I have here from our viewers is, if you go ahead and work for a company, you depend on them to do your H-1B application. Is it that you sit back and wait for them and their law firm to do everything, or do you have power as the petitioner under the company, under the employer, to have a say in the case?
That's a great question. So first and foremost, you're filing the case, right? You're going to sign your name if you're the petitioner on the petition, and that everything must be true and accurate, right? And you are committing perjury if you say certain things that are false if you knew they were false, right? So again, you can't accidentally perjure yourself. You have to intend to perjure yourself, and intent requires that. But your lawyer has to send it to you to sign. Your lawyer can't sign for you, can't do a power of attorney for you. So you have to sign off on these things. So a good attorney-client relationship is a collaboration, right? That's why we call this the collab. We love collaboration. We love to collaborate with other attorneys. We love to collaborate with our clients. That collaboration sometimes requires just the petitioner, just the beneficiary, and sometimes both, right? And it's really interesting in immigration law, and I love these because it makes me think about things that I don't think about regularly. But what's interesting about immigration law is, as the attorney, we're actually representing two different parties, the employer and the employee. In most instances, you would have in law, you would have somebody that represents one party and one represents the other. But this is a joint representation for a very specific issue. It doesn't go to all issues, right? And what happens to us sometimes is that the beneficiary or the petitioner may say, hey, I have a problem with this other person. That is your client, right? Now, we get our clients one of two ways. We either represent a company and we do all their beneficiaries work for them, or we represent a beneficiary that may go to a company and have them. So it's really interesting on conflicts, going back to law school. Yes, we have all sorts of tests here. We could pass a bar with the collab here. But how do you deal with conflicts of interest ethically when the beneficiary comes to you and provides you some information about the petitioner and you got the job through the petitioner. Well, I think most people practically would say, I represent the petitioner. You should go find another attorney. I can't say anything to you on that. But it does. But it's an interesting scenario, and there are instances where you'd have to recuse yourself completely. Maybe most of the situations, if there was a conflict that you can't, use information as an attorney against your client. That's what conflicts of interest are, right? So, pretty interesting the thing that you raised there, Pierre. So
Excellent.
finish your question. I didn't finish it.
Excellent.
That
Yeah.
a good petitioner, a good relationship is a collaboration. So what the petitioner should be giving the attorney is what's the job, right? I want someone to do this. Where the attorney comes in is helps him understand if that job is a specialty occupation, right? And where do they find that out? Well, there's a database that USCIS uses called the Occupational Outlook Handbook, the OOH. Our platform has a link to it. If you are building a visa in Visas.AI under the specialty occupation, there is a link that goes to the OOH, so you can compare that. Now, let me go into what's okay and what's not okay. So the OOH's description, you shouldn't copy and paste in for two reasons. Number one, they know what it is because they're looking at it and they're going to go, your job isn't real because you just told us it is what we think it is. Number two, it's vague, right? These are generalizations of what people do in a type of position. So if it's a software developer, it's going to say that they're going to maybe be involved in the design of a software application, that they're going to develop the software application, that they're going to test the software application, right? Those are the sort of things that a developer does. And that's kind of what the OOH says. But if you are doing a job description for a real job, and that's what USCIS is looking for, it's probably going to name the types of applications, maybe the computer language that you use, maybe some examples of types of work you've done on other types of clients. What USCIS wants you to do is tell you specifically which project is so that they can narrow it, but you don't have to do that. I think you can talk about the generalities of that, but being specific in those other things, right? So that's the specialty occupation piece. The attorney can suggest what one's work, but they shouldn't be making it up for you because they don't know that job. So the petitioner needs to say, here's what we're trying to do, where we're going to do it. And the attorney says, okay, if you do it this way, that's not going to work. Here's this way, that's not going to work. The second piece of it is, what are they going to pay? So yes, deals with clients all the time on, well, they want to pay this instead of that. Okay, then it's like, is there another job that meets that job description? Because they are similar, right? They are similar and they do pay differently, but it has to be real. It really has to be that. You can't say it's this and that. And sometimes you get in this all the time with people that want to get H-1Bs for their own companies, right? They want to be the CEO, but a CEO is going to have a prevailing wage way up here, right? Where a software developer is down here. Well, okay, you can be the software developer for your own company, but don't put on LinkedIn that you're the CEO because now you've violated that whole deal that you've underpaid yourself what you should have been paid for the position, right? And it is a really significant catch-22.
Wow. Every time that we talk about it, we just learn more and more. That's wonderful, John. We are approaching the end of today's collab, so I would love to get some closing remarks from Yash, and then Jay, and then we'll hand it back to you, John.
Thanks, Pierre.
Before we do that, we
Thanks,
actually have a
guys. As
question on
always, oh,
one of our audience at the YouTube. If we can answer him, he is actually they're watching, and they have if you have 204C bar on your case, what can I do?
204C bar.
Hmm.
Is that what you're saying?
Yep.
Is that what you said, Jay?
Yeah, they said if you have 204C bar on your case, what can I do? Let me see if I can put it into our chat, perhaps.
So the Section 204C of the Nationality Act bars a petition from being approved where the petitioner beneficiary previously participated in a fraudulent marriage. This significant penalty applies even if the individual never actually received an immigration benefit through the fraudulent marriage. Okay, so let's go back to the question. So 204C means that somebody made a determination that that person married somebody fraudulently, right? Is that what they're asking?
I believe so, yes.
Okay, let's see. Make the sausage right in front of people.
Mhm. You guys are seeing research, legal research in action.
All right. So a new BIA decision, that's the Bureau of Immigration Appeals, addressed the scope of Section 204C. So, and this was June 7th, 2022. According to the recent Board of Immigration Appeals, the BIA, a decision in the matter of PAC, that's PAK, and the stat number, or I'm sorry, the reference number is at 28 I and N. So that's I ampersand N in December 113 BIA 2020? The answer is yes. In PAC, a citizen appealed the denial of an I-130 on behalf of her husband, who had previously been a beneficiary of this sort of situation. So basically, I think we probably don't have the time to answer this in in detail, but there is a case law out there called the matter of PAC that talks about exceptions to those who've been found in violation of Section 204C. So I think an attorney could help dig into that and find what those facts are. I don't think we should discuss those facts on this open forum, but I suggest to that user or that viewer, yeah, feel free to contact any of the attorneys on this call or another one, and use matter of PAC as a starting point.
Yes.
Wonderful. Thank you so much, John. We appreciate you. We have reached the end of our time. Yesh, any closing remarks?
Um, just that it's always a pleasure coming on. I learn a lot more about other types of visas when I'm on here, so it's really helpful.
Thank you for joining, and we look forward to having you next week. I'll hand it over to John to close us off for today. Just a friendly reminder that everything discussed in today's collab is not legal advice, but rather a conversation by a for viewers and other attorneys. So please do not take anything we've mentioned or even our attorneys mentioned as legal advice, and consult for a full strategy session and or consultation with the attorneys on this call. John, over to you.
Thanks, Pierre, Jay, and Yesh. Always a pleasure to do the collabs. Love to talk immigration. This for me is a lot of fun. I want to wrap it back into Visas.AI. The tool that we developed is an essence of this, right? That's why we have this show, right? Collaborating with other attorneys. Visas.ai allows you to collaborate with your clients to get onto a screen just like this. That's the responder. It's the app that we want to show. So in the Visas.ai tool, you're able to have a screen that allows you to have these types of conversations with your client. And what we developed is these strategies. We call them winning strategies, the use of regulations, policy memos, AAO decisions, which are the agency decisions in federal court cases, to help you make the right calls for your clients, right? So look at it, use it, take them through. What we've done that's different is we've taken out from the series of questions that you need to ask a client to do a case, the strategic ones, right? The strategic ones are like we talked about. What makes a job a specialty occupation? If a client doesn't want to pay the prevailing wage for one, is there another specialty occupation? Instead of just saying no, we say we invite those questions. We want to go through that, right? And that's what can help you build the most successful case. We'd love you to come check it out. We'd love to show you a demo about it. It's really been fantastic for our firm. We'll file a whole lot of H-1Bs this year in this month, and we're able to do that with people around the globe and have quality control. And we want to maintain our 100% approval rating in our firm for those, because we're able to have people from many different places put their hands into it, but still have our strategy be executed to create the documents that we want to create, and know what they're going to say and trust that they're going to be the right thing. And when we look at them, it's easy to see them and make changes even at the last minute and get it done.